The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another program in this public service nation-building series, The Law and You. This is program number 888 and it is coming to you on Monday the 8th of January 2018. All the 8s. First thing I want to say is Happy New Year to one and all. Secondly, I would like to send my condolences to all families which have suffered recent bereavements, and in fact bereavements throughout 2017. On this program, I will speak to you on the topic changes in civil procedure since 2000. Now, most of you by now would know the difference between civil cases and criminal cases. And the way the difference is defined, we normally defined criminal cases to be those involving prosecutions, and civil cases, all other categories of cases not involving the prosecution of an individual for an offense. Now, the bulk of cases coming before the courts are civil cases. And in 2000, there was a massive change in civil procedure when the old rules of court were put aside and we started using the new rules of court called the Civil Procedure Rules 2000. For all of us in the profession, particularly those who were there at the time, it was a time of some turmoil because it took a while before we got accustomed to the new rules. You know, when you were accustomed to doing something under one set of rules and then there's a radical change to another set of rules, it does take a while to get accustomed to that. But by now, the profession is attuned to that. And of course, those lawyers who are called to the bar in or after 2000 don't know what it was like to practice under the old rules. So they just, the new barristers and attorneys just know life under the new civil procedure rules. Now, under the old rules, we had things like writs. You don't hear about writs again because they have gone out. The person who filed a case in the civil court was called a plaintiff under the old rules. Under the new rules, such a person is called a claimant. Or if one is applying for a particular order, you may be called the applicant. But the old word plaintiff out of the window. The general philosophy behind the new rules was that litigation in the civil courts was really taken over by the court and not left in the hands of the lawyers solely. We adopted the 2000 regime following the changes made a few years earlier in England. Now throughout the Caribbean, the new rules following the English revolutionary changes are in force. And the guiding figure behind the bringing in of the new rules was an English judge, very eminent judge called Lord Wolfe. He is regarded as the architect of the new civil procedure system. Now, under that system, from the time a matter is filed, it is entered into the court's computers, and theoretically thereafter the court takes charge and mandates a timetable for the taking of certain steps, the filing of certain documents, the doing of certain things. One of the main purposes of the introduction of the reforms in England was to cut down the severe backlog, because it was found in England that there were literally thousands of cases which were in the system not going anywhere because the lawyers, for one reason or another, couldn't be bothered. I suppose that's a little harsh judgment. But things were very, very slow. People not getting the cases heard. There were many complaints about the system, so they decided let the courts take over the management of civil procedure. Well, we adopted that system here. We had backlogs as well, but our backlogs were caused mainly because of the strain on the single judges which we had in many of the Caribbean jurisdictions, particularly in St. Vincent and Grenadines. There were simply too many cases for them to cope with. Although there were individual judges of a radical disposition who saw to it that their lists were always kept up to date. So in theory, this system was meant to move cases along, not to have any backlog, not to have people have to wait years and years and years for the trial of their cases. So one of the distinguishing features of the new civil procedure system is that almost every procedure in court has a deadline. So there is hardly a time when a particular matter hasn't got a deadline for the next filing or the next hearing of that particular matter. As you can imagine, this imposed an enormous strain on lawyers in the early years. Because before you wink, one deadline, two deadlines, three deadlines were upon you. And one of the things we discovered in the profession, within a few years of the Civil Procedure Rules 2000 coming into force, was that it was no longer tenable for a single lawyer to run a practice in the new system. In fact, some judges have come out quite plainly and have said the days of the single practitioner are over. Of course, we still have a lot of single practitioners here in St. Vincent and Grenadines, but I can tell you they operate under enormous strain. And most of the single practitioners are looking to group themselves together either informally or formally. Now, one of the imperatives of the new system is that clients have a duty to keep in touch with their lawyers. And the courts have ruled that if anything goes wrong, a lawyer can come and say, well, he hasn't heard from his clients for a long time. He doesn't know the whereabouts of their client. Because when you take instructions from a new client, you receive the client's cell phone number. But people change their numbers frequently and they don't always remember if they have a lawyer to give the lawyer the new number. So many lawyers find themselves having a client whom they can't contact because the cell phone number the lawyer was given initially has been changed. So let me remind you, if you have matters with lawyers, every now and then phone them up and let them know where you are and inquire about your case. One of the pressures facing lawyers in the new system is that if you miss a deadline for filing a document, you, the lawyer, can be charged a fine called a wasted costs order by the judge unless you have a very satisfactory reason why you missed your deadline for filing your documents. Usually the fine which a lawyer has to pay is $500, sometimes $1,000 if the situation is an unusual one. So lawyers are under pressure to file on time. And where a lawyer is depending on his client to give him information so that he, the lawyer, or she, as the case may be, can draft the document to have it signed by the client and filed, then it is impossible to meet deadlines because you simply can't get in touch with the client. Now, this fine, I refer to it as a fine, even though the proper name is a wasted costs order. When the lawyer pays that into the court, it doesn't go to the other side, it goes to the government. Hence, I call it a fine. And therefore, the pressures are always there on the legal profession. Now, one of the institutions brought into being under the new Civil Procedure Rules 2000 is the institution of the master. So, those of you who have civil matters with a lawyer perhaps will hear that the master says, we have an appearance before the master. Your lawyer will say, we have an appearance before the master on such and such a date. And you will inquire, who is this master? And the lawyer will explain to you that the office of master was brought in after 2000 as a sort of deputy judge. Initially, masters were appointed, one to serve the southern Eastern Caribbean, that is the Windward Islands practically, and one to serve the northern Eastern Caribbean. And then it was found that the volume of work was simply too much, and more masters were employed. by the Chief Justice. Now, I said a while ago, a master is a sort of deputy judge. A master has most of the powers of judges to deal with procedural matters. So that under the new system, before a case goes to court, it has to pass through the master, who has the responsibility to make sure that the requisite documents have been filed by all sides, all parties to the litigation, to make sure that the case is ready for trial, and so on. So that by the time the trial date arrives and the judge calls the matter up, everything is in order. Ideally, there are times when things go wrong, but that is the ideal to which the system aspires. There are some instances in which a master has the responsibility to assess damages. For example, if there is a case involving injury to the person, the judge may decide a case in the favor of the claimant or the defendant and send the case to the master to assess damages. Then the master has a role to hear all of the particulars of the case and to decide how much monetary compensation to pay to the person whom the judge has decided has won the case and is entitled to damages. If the defendant wins the case, well, there's no question of damages. But if the claimant, the person who brings the case, who complains that he or she has been injured in an accident or had his or her vehicle damaged in a motor accident, if he or she wins the case, then the question, how much monetary compensation should be awarded to that person, those questions are normally settled by the master. So the master has a hearing. The position of master is a very serious one, and most of the masters we have had since 2000 have gone on to be appointed full-fledged judges. So if you look in the system now, in the OECS, and my conversation is really about the OECS jurisdiction. Similar in Trinidad and Tobago, Barbados, Jamaica, Belize, Guyana. But my discourse centers on the Eastern Caribbean, excuse me. So the office of master is a very important one under the new rules, because the court's responsibility to manage cases is primarily exercised by the master. And there's a process called case management, which is the process by which the master looks at a case in the early stages and arranges a timetable with the parties when you should file this document, when you should file the other document, who should file X other document, and so on. So that case management function is one of the main responsibilities of the master. Now, most masters have been female in the OECS system since 2000. In fact, I think very few masters have been males. Notwithstanding that, you don't use the nomenclature mistress. So even if it's a female, you still say master. Maybe one of these days the women lobby will get up and say, no, we don't want to be called masters because we are female, but that is for the future. So far, throughout the British Commonwealth, the term master is used for both sexes, and nobody seems to have agitated against that up to this time, as far as I'm aware. Now, because of the new structures under the 2000 Civil Procedure Rules, we in St. Vincent and the Grenadines found that it was impossible for one judge to deal with civil procedure. And before long, after 2000, we were given 2 civil judges, in addition to the 1 judge handling criminal matters. Which is why in St. Vincent and the Grenadines right now, we have 1 judge who exclusively handles criminal cases, and that is Justice Cottle, and 2 judges who handle civil matters. The master is an itinerant office, travels, goes to one island for a week, then another island. Nowadays, the system has expanded. So from this January, we in St. Vincent and Grenadines would be getting a sort of semi-permanent master who will be sitting here all the time until he, because it's a gentleman who's coming, until he is sent to another jurisdiction, and then somebody will replace him. Because they not only has civil procedure increased in volume, but as I said before, because of the tightness of these deadlines, you find that the Master's Court is normally busy, and the 2 civil judges normally have their hands filled at any one time. Now, one of these programs, I will speak to you about changes in the criminal courts. But those changes have not been as dramatic or as drastic as the changes in the civil courts. Now, one of the things which is regulated in the Civil Procedure Rules 2000 is the fee structure, the structure of legal fees to which lawyers are entitled. And whenever a case is determined, there is a particular rule under which the parties and the court can work out the amount of costs payable by the losing side. As you know, because I've told you this from time to time and you would have heard it elsewhere, particularly those of you who are involved in court cases, the general rule in civil litigation is that the loser pays the legal costs, not just of himself or herself, but the costs incurred by the winning side. So generally, if you lose a case in the High Court, you pay the costs of the winning side. But there is a table, or there are several tables, by which those costs can be quantified. If it is a difficult case, then the master would deal with the quantification of costs where they cannot fit into the schedule that you find in the table of prescribed costs. In recent weeks, and I spoke about this in December, the Chief Justice has increased the fees and charges for certain types of matters, so that whereas before the Chief Justice brought in those rules, and they were brought in during the course of 2017, whereas certain matters were relatively inexpensive for the parties, I'm afraid to say it is now very expensive to file certain applications in court and to undertake certain procedures. For example, applications for letters of administration and probate. The fees are relatively modest. All of a sudden, those fees have shot up. And not only have they shot up, but the Chief Justice has brought in a new rule that every application for letters of administration has to be advertised in a newspaper. Before that came in, a person would apply for letters of administration. You pay the normal filing fees, and it was a relatively inexpensive process. Now, you begin by putting an ad in a newspaper, giving notice of your intention to apply for letters of administration or for probate in the estate of so-and-so, and then you go and face higher fees for the filing of every single document. The profession in St. Vincent and the Grenadines has reacted with some unhappiness, because given our economy, and these rules the Chief Justice brought in were across the board. They were applicable in all jurisdictions, in all parts of the Eastern Caribbean, from Anguilla in the north to Grenada in the south. Now, the economies in these islands vary. And we in St. Vincent and Grenadines reckon that some consultation should have taken place with the legal profession in St. Vincent before those impositions were made. In fact, it would appear that the government was taken by some surprise, the government of St. Vincent and Grenadines, from what I've heard government officials saying, because lawyers naturally complain and say, how come these things have gone up? How come you all have agreed to these things? And one government official at least said, look, not that we agreed, we had no choice, we didn't know. We are simply told that these are going to be the new charges. But I'd say that, by the way, because whatever they are, we have to pay them once that is the law and once those are the rules. Now, let me end this program by once again urging you, where you have matters which have the potential to ripen into legal disputes, try and get them settled. Civil litigation is an expensive process, not just expensive, it is stressful. Ask anybody who has had a case pending for 5, 6, 7, 10 years, and they will tell you how stressful it is. So for heaven's sake, if you can settle your matters, settle them. Don't go to court for every quarrel you have with a relative over a piece of land and so on. Try and settle your business peacefully, much less expensive than if you have to go to court. All right? So once again, let me wish a Happy New Year to one and all. And I look forward to being of continued service to you on this public service nation building series, The Law and You. Until next week, ladies and gentlemen, brothers and sisters, boys and girls, do have a blessed and productive and peaceful week. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.